online at the Springsport Clinic. Also joining us today is Professor Cole. He is an IU Maurer professor. He will be giving the response to today's discussion. He's an internationally recognized environmental law and economics scholar who joined the Indiana Law faculty in 2011. Most of his writings are at the intersection of law, economics, politics of property, natural resource law, and use in environmental protection. Cole is the author of 7 books and more than 40 articles. Cole is a founding member of both the Midwest Law and Economics Association and the Society for Environmental Law and Economics. He's a life member of the Clare Hall of Cambridge and has served as a visiting scholar in the faculties of land economy in the University of Cambridge. In the fall of 2020, Cole was the John S. Lehman Distinguished Visiting Professor of Law at Washington University in St. Louis, and before moving to Bloomington, he was the R. Bruce Townsend Professor of Law at Indiana University McKinney School of Law. In 2020, he was named the Robert H. McKinney Professor of Law. So please welcome, immediately join Mr. John Blackman as he discusses the conservative legal movement at the Dobbs.
Thank you. It's a pleasure to be back here. I was last in this room in February of 2020, like right before the world shut down. So it's good to be back here in person. It was great. We're all just sitting here in Chick-fil-A. It's like nothing happened. Um, the conservative legal movement is sort of hard to define, but I'll do my best to do it. Microphone. Starting in the 1970s and 80s, really after Roe, there was a sense that the judiciary had gone a bit too far from where most conservatives were. Indeed, many Republican appointed judges over the decades had leaned and went hard to the left. Earl Warren, William Brennan, Harry Blackmun, and the list goes on and on. And starting in the 70s and 80s, there was a notion that perhaps conservatives should rethink their approach to jurisprudence. This manifested itself with the creation of the Federal Society in the early 1980s. Now, contrary to what you may have heard, the Federal Society was not built as this sort of monolithic organization. It began as a group of students at the University of Chicago, at Yale, at Harvard, who had simple ideas about limited government, courts following history instead of modern conceptions of justice, and using student networks to perhaps develop a new generation of lawyers who could change the legal order. The Federal Society came of age around the same time as the Reagan administration. And indeed, many of the young members of the Federal Society, the directors, went to work in the Reagan Justice Department under the leadership of Attorney General Ed Meese. And around the same time, President Reagan made a couple picks to the Supreme Court. One of them, you may have heard, his name was Antonin Scalia, who was a professor of law and later became a justice. And so these sort of three confluence of events, you had Attorney General Meese in the Justice Department, you had the Federal Society, this young group of lawyers, and then you had Justice Scalia on the courts. And this trifecta kind of merged at the same time to create this new legal movement. The idea was we would now have not a monopoly on the left in legal academia, you'd have also a force on the right. Okay. Now, what was the rallying cry of the conservative legal movement? There were a couple. One was the notion of limited federal government. At least for a time, the notion was a restrained judiciary. Not sure that's still the mantra today. And the other mantra was originalism, the idea that courts should adhere to at least the intentions or later the understanding of how the framers understood the Constitution. But sort of lurking in the background was this cultural component, and that was abortion. Behind all of the conservative legal movement was a single sort of bullseye, a target, if you will, which was Roe v. Wade. And the hope, the prayer, the dream was that one day Roe could be overruled. We flash forward to 1992 with Planned Parenthood versus Casey, right? This is a case I'm sure you studied. Finally, there was a chance for the court perhaps to overrule Roe, but it doesn't. And indeed, justices appointed by Ronald Reagan and George H.W. Bush cast the deciding votes to reaffirm Roe v. Wade. And this was a setback to the conservative legal movement. How could it be that now even our own judges are still voting to reaffirm a decision like Roe? So the movement doubled down and reaffirmed itself to try to find judges who would not be so easily swayed by social pressures and otherwise, who could at least see that Roe is a wrong decision that should not stand. And over the years, the federal study grew and grew and grew. I became a member when I was a first year law student, and it's just remarkable how much it's accomplished in a short period of time. But really, the turning point came in 2016. February of 2016, to be precise, just about 7 years ago to this week, I think. Justice Scalia suddenly passed away at a hunting lodge in West Texas. If you recall, unless you're living under a rock, we were in the middle of a presidential campaign. And that evening, Donald Trump had a debate. The same evening Scalia died, there was a debate in Charleston, South Carolina. And a question was asked, who would you put in the Supreme Court? And then Trump came out and he gave a couple names. He mentioned Bill Pryor, who's a federal judge in Alabama, and Dianne Sykes, who's a federal judge in Wisconsin. He understood, for better or worse, how important judges were to Republicans. He got that. He understood what happened with prior Republican nominees, John Roberts perhaps most recently. And he played this up. Trump would put out a list of people he would nominate to the court. By the way, the 3 people he picked for the Supreme Court, none of them were on the original list. So the list was worthless, like most things Trump put out, right? Promises kept, right? But he made other lists when he wanted other people on the court. But the deal was he put out a list, right? He put out a list of the people he wanted to put on the Supreme Court. And this signaled how important the issue was. And Trump was actually quite candid. He said, we will put judges in the court who will overrule Roe. He was very candid on this point. Perhaps a little too candid. Probably was. The election happened, and much to, at least my surprise, maybe everyone else's surprise, Trump prevailed. And a couple months after his inauguration, he appointed Neil Gorsuch to the Supreme Court. And then over the next year and a half, lots of weight was pushed on Justice Kennedy to step down, and he did. And who did Trump nominate to replace him? Well, a Kennedy clerk named Brett Kavanaugh. There might have been some understandings going on that we don't know for sure. So then we get to 2020. 2020. All right. And there's a case that sort of was an inflection point, if you will, a tipping point almost. It was called Bostock versus Clayton County, Georgia. Right? This was actually a series of cases that considered whether the Civil Rights Act of 1964 prohibits discrimination on the basis of sexual orientation or gender identity. Right? At the time, there were 5 Republican appointed justices, 5 conservatives, and there were 4 liberal justices. One might think that this new conservative movement would flex its muscle and say, no, this is insane. A statute passed in the 1960s can't possibly protect LGBT rights, right? That's just insane. And then we have the majority opinion by Justice Neil Gorsuch, joined by the Chief Justice, ruling that Title VII does prohibit discrimination on the basis of sexual orientation and gender identity. There was a vigorous dissent from Justice Alito. Justice Kavanaugh wrote dissent. Justice Thomas was also in dissent. The vote was 6-3. This ruling was sort of a shot across the bow to the conservative legal movement. It said, wait a minute, what exactly are we fighting for? We spent all this time and effort to put Gorsuch on the bench, and yet he votes in a way that conservatives find so undesirable. How can this be? And this is where there was a schism almost formed. Now hold up your book, please, Mr. Cole. Wave it around. So around the same time, a professor, you may have heard of him. His name is Adrian Vermeule at Harvard. He was in Chicago for many years, but he's been at Harvard for some time. And Adrian came out with this article in the Atlantic called Common Good Constitutionalism. Common Good Constitutionalism. And he says, enough with originalism, right? If originalism and textualism gets us a case like Bostock, who needs it? And he called quite candidly for a conservative jurisprudence grounded in what he calls the common good. They might ask Josh, what is the common good? Adrian's always a little bit cagey on where that comes from, but it might be based on religion, might be based on Catholic integralism, the idea that the Catholic Church be integrated into our civil society. It might be based on the common law, perhaps, traditional values. We can argue over what that actually means. But Adrian said we need to move away from this sort of empty, vacuous, seemingly objective jurisprudence of originalism or textualism and imbue our law with certain anchoring truths, certain principles. You see this sort of arguments presented also by Hadley Arcus, who's at the James Wilson Institute, and a few others. Now you might think, wait a minute, Josh, didn't we just spend 30 years trying to promote originalism? Where the heck is this other common good stuff coming from? But again, there was an opening. If the conservative legal movement yields decisions like Bostock, then that movement may not be long for the world. And at the time, I was sort of worried because I'm an originalist. I like this stuff. And I was worried that, young, impressionable minds like all of you could look to Adrian as a Pied Piper and follow him to the depths of Rome, right? But there was a moment. Indeed, Senator Josh Hawley, who was a FedSoc member, a president of the, I think he was a member of the Yale Law School FedSoc chapter, said, if this is what conservative movement gets us, who needs it? Let's move on. So I said, okay, things are nervous. Next big turning point was in September of 2020. Justice Ruth Bader Ginsburg suddenly passes away. If I have allergies or something, congestion. Ginsburg suddenly passes away. President Trump could have said, okay, we can put in a nominee after the election or let the next candidate do it. That was not gonna happen, right? There's no way in hell, right? So instead, they pick a native, or not native, but a resident of this state, of Indiana, Judge Amy Coney Barrett, who was a professor at Notre Dame for many years. And they put her through the process in a span of a few weeks. It was very fast. I mean, it was over. And Barrett was confirmed a few days before the election. Let's just pause for a moment. Imagine if they'd wait till after the election to do the nomination with all the election fraud and the January 6th stuff. It would never have happened. Nope, never have happened. So the decision to put it forward before was, I think, pivotal. But now, there were not 5, there were 6 conservative judges on the Supreme Court. This was the most conservative court since the 1930s, since before Franklin Roosevelt came to town. And almost immediately, people started panicking. There was a call on the left to expand the court packing, if you will. Court reform, I use the scare quotes lightly. Term limits, stripping the court of jurisdiction to hear certain types of cases. All sorts of proposals were bandied about. And even President Biden appointed a commission to investigate it. Fortunately, that commission went nowhere fast because he said, I don't care about the recommendations. There's this big report that's collecting dust on some hard drive somewhere. But now that Barrett was on the court, the abortion issue would come front and center. The Supreme Court granted review in a case called Dobbs versus Jackson Women's Health Organization. Dobbs was a case from Mississippi. Mississippi enacted a 15-week abortion ban. Now you might think, wait a minute, Josh, isn't under Roe v. Wade in case you can't ban abortion before viability? You're right. Mississippi enacted law that was blatantly unconstitutional under law. Right? It squarely violated Supreme Court precedent. But the goal of that law was to create what's called a test case, a vehicle to challenge, to overrule the Roe decision. The lower court found the law was unconstitutional, correct? It had to. The Fifth Circuit, a very conservative judges, found that the law was in violation of Roe and Casey. But then it gets to the Supreme Court, right? This was the crowning moment, what decades of work had been leading up to, what people like Mies, in other words, had just looking forward for generations. Then the question became, would there be 5 votes to overrule Roe? Would there be enough votes? Would Kavanaugh, would Barrett, would Roberts, would Gorsuch go along with it? And then lurking in the background is my friend Adrian up in Cambridge, plotting. And I actually think Adrian would have liked if Dobbs came out the other way. I'll explain why in a few moments. But I think I think he, of course, is very much pro-life, no question. But I think it would have helped his movement more had Dobbs come out the other way. And during the year that Dobbs was pending, I publicly stated that if Dobbs came out the other way, if Dobbs upheld Roe, the conservative legal movement would fracture, be a schism. It would not have existed the way we do today. And I think that absolutely weighed on the minds of Kavanaugh and others. This wasn't just about abortion or precedent, it was about the movement that brought them to life, right? There's a reason why they're at the Supreme Court. It's not because he likes beer, right? It's because of the movement behind him. I'm sure he knows that. So Dobbs is brought to the court. Pressure from all around. Every law professor in the country said, if you overrule Dobbs, it will be bad for the court's legitimacy and these sorts of things. We heard these things nonstop. All these op-eds were published about how this would destroy everything, that you'll have these portions of the country, abortion deserts, where you'll not be able to obtain an abortion. The arguments were stark, painted. People will die. There'll be health consequences. Okay. Case is argued. The case is submitted. We now know that after the case was argued and there was oral argument, they have a conference. And we know with some degree of certainty that the conference, there were at least 5 votes to overrule Roe and Casey. How do we know that? Well, there was a leak. There was a leak of an opinion. A draft opinion was circulated, and somehow that opinion made its way to Politico, the online news site. In fact, we really don't know because the Supreme Court doesn't even know. They did this lengthy investigation that yielded bupkis. They just don't know how it happened. But someone thought it significant enough to leak the opinion because of what they were trying to accomplish. Now, was this a conservative leaking the opinion to try to lock in the votes to make sure that Kavanaugh didn't go wobbly in the knees? Or was this a liberal leaking the opinion to try to shame the court and maybe put pressure on the justice to flip? Whatever happened, though, the opinion came out. And then shortly after this opinion came out, there were protests at Justice Barrett's home, at Justice Kavanaugh's home. Daily protests. Their children, their young kids had to walk past us every day. And then a person tried to assassinate Justice Kavanaugh. His purpose was expressed to try and stop him from casting the 5th vote in Dobbs. He was very clear on this point. Thankfully, he didn't do it, and he seemed to have either backed out or had second thoughts. We're not entirely sure. There's a pending murder charge against him right now. He's in federal court in Maryland. Okay? We get to the end of June of 22, about 6 months ago, and then the Dobbs opinion drops. It's more or less unchanged from the draft opinion. There are some changes here and there, but nothing substantial. And there were 5 votes to overrule Roe. The Chief Justice could not bite the bullet. He simply said, well, I'm going to rewrite Roe rather than overruling it, which is, you can praise him for minimalism, but there's nothing genuine about what he did. He just made up a precedent. He just rewrote it. All right. Now, this brings us to the present, right? What does this mean for the conservative legal movement? Have you ever read Moby Dick when you were in high school? Remember the white whale? Well, the conservatives got their white whale. They got their Moby Dick. And they got some other stuff along the way also last term. In New York State Rifle and Pistol Association versus Bruin, the court extended the Second Amendment to outside the home. They adopted a very difficult test to satisfy. Gun control laws are now in a very precarious place. You have a case called Kennedy versus Bremerton School District. This involves prayer by a football coach before games. The court overruled the so-called Lemon test, which made it very hard to have religion in public squares. Now it's much easier. This term, the court will likely overrule Bruder v. Bollinger, which was a precedent that allowed affirmative action in law schools, like we are right now. So in a very short period of time, we're seeing a sudden shift in cases. Now, we can talk for hours about where the court's going, but my invitation was a little bit different. The invitation was, what does this mean for the movement? Right? So one question is, what is the next big white whale? Is there even one? Is there a single cause that unifies conservatives, social conservatives, economic conservatives, right? The movement with the lawyers. And the short answer is not really. There are lots of sort of niche issues that have constituencies. Religious liberty is important to some. The Second Amendment is important to some. The administrative state is very important to businesses. Regular people don't really care, but the chamber seems to really care about Chevron. I don't care about Chevron. Really, just on my list of 100 items, Chevron's towards the bottom. I just don't care. Um, you're not going to have people marching in Washington to overrule Chevron. That's just not going to happen. Um, and I think that's both a good thing and a bad thing, right? Because there's a unifying cause that still allows spheres for different wings to sort of accomplish their goal. But the next confirmation hearing won't be the sort of singular focus on abortion. So in that regard, Dobbs liberated the court from this sort of specter that's been on for 30 years. But now I've been talking a lot about conservatives. What about the other side, right? What should be the project of progressive jurisprudence, progressive judges? Like, what should they be focusing on? There have been reports that Justice Kagan is sort of unhappy. These are always planted in the media, right? But why is she unhappy? She's the schmoozer. She's the deal maker, right? She helps bring people together. She was very good at that in the Harvard faculty. I think she actually brought Vermeil to Harvard, if memory serves. And Kagan was very good at bridging Kennedy and Roberts to make things happen. But her deal making skills are now weakened because she doesn't have any partners to deal with. Roberts is only 4. She doesn't have a 5th. Right? So perhaps the strategy then is to turn to what Justice Sotomayor does, which is basically throw um, uh, these very strong dissents that speak to the sort of the personal, the human issues human issues present in these cases, right? Justice Ginsburg would often say her dissents are written for the ages. They're written for a new generation that doesn't even exist yet to see how wrong things were. The same way we might read a Holmes or Brandeis dissent from the early 20th century, maybe the purpose should be writing dissents that are read decades from now. Or maybe another approach is that of Justice Ketanji Brown Jackson, the newest member of the court, who seems to be trying to do sort of a liberal originalism or progressive originalism, or what Jack Balkin might call living originalism. We saw this in the affirmative action case and in a few other decisions this year. Um, again, so the 3 strategies. One, try to moderate and build consensus to get to 5. That's the Kagan approach, I think. Another approach might be to um, just throw bombs and hope to land very strong rhetorical points. It's a Sotomayor strategy. Maybe Jackson tries to develop an alternate liberal strategy. And I don't know which one's going to coalesce, which one will garner more support over time. What I do think will happen, though, is that increasingly law students and lawyers will become sort of detached from the current court, right? The court was long celebrated as a sort of champion of justice that secures the rights of minorities. And I think that vanishes, that goes away. That doesn't stay. And over time, we have these sort of never-ending, constant attacks on the court and its legitimacy. That does diminish how much respect people have for the court. Whether this leads to things like court packing or otherwise, I'm not certain. I think that we're ways away from that. Now back to conservatives, right? Conservatives for the longest time have been on defense, right? Criticizing whatever the Warren court spit out, criticizing whatever stuff Justice Kennedy wrote on a cocktail napkin, right? We're just criticizing the other stuff. But to quote a line from Hamilton musical, winning is easier, governing is much harder. I think one of the biggest challenges facing conservatives, okay, now you got 5, maybe even 6. What are you going to do with it? Right? What are you going to do with it? What are you going to advance. And I'll use Bruin as an example, the Second Amendment case decided last June. The court didn't simply say that Second Amendment rights are subject to strict scrutiny, right? That would be something familiar that we know. We know what strict scrutiny is. We know how it works. Instead, Justice Thomas said we are not applying any scrutiny, any means and balancing whatsoever to the Second Amendment. Instead, we will use what he calls a text and history model. And specifically, we use analogical reasoning, right? Analogical reasoning, right? If there's some gun control law today, we would ask, are there similar analogous provisions in the past? As we have very tight fit. So if the government's banning people from having a gun today because they don't, like them or whatever, was there some similar law in the past? And this is a very hard standard to satisfy, right? Because frankly, there weren't many gun laws back in the day, right? There weren't many laws dispossessing people with mental illness from having guns because we didn't really know what mental illness was, right? There are lots of things that exist today that didn't exist in the past. And the framework the court adopted, if applied, I'm going to say unfairly, could lead to a lot of laws falling. Now, I think the court standard is actually a good one, but I think there's a temptation to apply it too rigidly. So, for example, one district judge held that a law requiring serial numbers on guns unconstitutional because there were no serial numbers back in the day. Well, of course, no serial numbers. It wasn't a thing. The serial numbers didn't exist. So I think the test the court had can work, but I think we need to sort of refine how it's modeled. And that's what I mean. Like, winning is easy, governing is much harder. For the next generation or so, unless there's substantial court expansion, conservatives will have a majority in the Supreme Court, and probably the judiciary as well. Biden's appointing lots of judges, but we'll see what their influence is. I think the Trump judges will have a much bigger, they'll punch above their weight class for a while to come. They're young. They're hungry. They're hungry, but they're ambitious. And that leads to all of you all, or at least most of you, law students, right? What are you going to do with this new legal order, right? Do you just make arguments like you've always made, or do you start adapting your arguments to the court that you see? I think that's a tool you should all learn. If you have originalist judges, not just on the Supreme Court, but on the Seventh Circuit and elsewhere, or the Indiana Supreme Court even, your argument should be geared towards that methodology. Even if you don't like it, even if you disagree with it, if you are a competent lawyer with a duty of advocacy and a duty to your client, you need to use these arguments, which is where we come in, law professors. Law professors, I think, now have a duty to teach this stuff to their students, right? Not just as a caricature, not just saying, oh, yeah, that's just something Scalia does, it's whatever, but actually. Thank you.
Okay, I have just really a couple main questions, but they're fairly big ones, I think. Josh mentioned this book, Common Good Constitutionalism by Adrian Vermeulen. He's not standing by himself out there making these arguments based on Catholic integralism, that the Constitution should be rooted in Catholic principles and take direction from the Pope. This Thursday, Patrick Deneen is coming to IU, and I don't know, Nick, he's an integralist, basically. Yeah, more or less. He's not a law professor, he's a political theorist. But questions I've been thinking about for a long time are about, we know that the national conservative and Christian nationalist movements have in some ways fractured the Republican Party. And so one question would be, to what extent do they pose a real threat of fracturing the Federalist Society, given its its core principles as stated on its website, which you can read for yourselves. On the more specific question of Justice Thomas's ruling on gun control, I'm not so sure that it's not possible to find analogs. Throughout the Old West, you find cities that required entrance into the town to check their guns at the city limits with the sheriff's office. That's more powerful gun control than most places have today, and yet no one seemed to think it was unconstitutional at the time, or if they did, they didn't have enough power to stop it anyway. So there's that kind of thing. I think, once you start digging around in history, you find lots of things. And the only other thing I want to say about this is, my perspective as a moderate liberal is that the Federalist Society historically has been comprised of liberals, largely conservative liberals as opposed to progressive or moderate liberals. And then the American Constitution Society is mostly almost all progressive liberals. I don't belong to either organization because I'm a moderate liberal, I guess. I don't know. But having both these groups in the mix is important for balancing interests. It's important politically for the country. And, make no mistake about it, when Posner described the Supreme Court as a court of politics rather than a court of law, he was absolutely right. And it's still that. I think, whatever the claims of originalism, and by the way, Dworkin does a pretty good job of just, throwing originalism in the dustbin, and Vermeulen follows him up. He's very much a Dworkinite when it comes to that there's no form of legitimate argumentation in the court that is not political. And never has been. And so I think once we accept that, most people want, I don't know what most people want. It's important to have conservative representation, and conservatives are underrepresented in law schools and academia. By far, I have a very good friend who's a member of the Federalist Society for a very long time, was in the Reagan White House, wouldn't even be considered for a job because of his association with the Federalist Society. I think that's anybody with an ounce of sense should be offended by that kind of thing happening. Shouldn't happen on either side. But whether the court is activist or restrained sort of depends on your point of view. Right now, progressives think the conservative majority in the Supreme Court is extremely activist, in much the same way the conservatives thought the Warren Court was extremely activist. How long that's going to continue, it's hard to say. It's a big majority right now, 6-3. 6 members of the Supreme Court right now are members of the Catholic Church, although one of them is on the liberal side, Sotomayor. So you have a 5-vote majority that might well come to favor something like what Vermeulen's recommending here. In a country where Catholics make up only a minority of the population, the majority or at least plurality of the population is Protestant. Protestants are underrepresented on the court, maybe for the first time in American history. Anyway, so those are just some general thoughts. Josh can make of them what he will or won't. The main questions I posed earlier.
Sure. Thank you so much for that. Let me talk about fusionism for a minute, which I probably should mention earlier. So what is fusionism? Going back to 60s, maybe? I'm not sure when. 60s, 50s, 60s, 70s, depending when you want to count. What do you think?
I don't know, Maritain, so earlier even.
Well, at least 1960s, there was a notion of fusionism. And what's that mean? That conservatives and libertarians could find common ground on certain issues to advance shared agendas. So maybe Barry Goldwater might be an example, William F. Buckley to some degree. Libertarians, which is where I sort of am politically kind of, get more conservative as they get older maybe, would find common ground. And a lot of this focused on economics, right? Limited government, personal freedom, low taxation, things of that nature. And that was sort of like this Venn diagram where conservatives and liberals would find common cause. President Reagan, I think, effectively tapped this fusionism and even brought along the so-called Reagan Democrats, people who are economically conservative and maybe more liberal socially. In recent years, I think that's sort of breaking apart, and maybe Professor Cole has thoughts on this as well. Trump is very much in favor of populism, in favor of strong protectionism, globalism, opposition to globalism, for example. And many people who are conservative are finding less and less common cause with libertarians on the economic issues. So as a result, maybe more libertarians will trend towards the Democratic Party, who though perhaps tend to favor more socialist political policies, may have more ground on the social policies like abortion and gay rights and otherwise. So what does this mean for the Federal Society? If the sort of religious conservatives take bigger hold in FedSoc circles, that'll push out a lot of the more classical liberals. And to the end, I agree that conservatives are underrepresented in the academy. Libertarians fare actually better.
Yeah.
Without question. I went to George Mason for law school. There are a lot of libertarians in the faculty and some social conservatives. That's an outlier. So you may actually see more of a schism in the sort of academic-y FedSoc wing than you see in the rank and file membership. And you'll see less support. In terms of the court being, a political institution, sure. I mean, we could perhaps say that. I think it's perhaps less politics than Professor Cole does. But I think what a lot of the court's trying to now is sort of retrench or to sort of, as I say, control Z, that is undo some of the precedents of the Warren and Burger Court. Really more of the Burger Court, if you think about it. The court isn't overruling Griswold v. Connecticut. They're overruling Roe. Right? They're not going to overrule, Loving versus Virginia. They'll overrule, Bakke versus Board of Regents, right? They overrule the Abood case involving public sector unions. A lot of the cases overruling go back to the 70s and the 80s, not the 50s and 60s. So it's almost like this line of, okay, we'll go this far, but no farther. We won't go any further back. And I think what a lot of it is just, okay, you had your run, and sort of now it's our turn. And we'll see what kind of precedents they can entrench. Finally, in terms of the sort of the religious movement breaking apart conservatives, I think that's sort of Adrian's dream. I'm not sure how far it went. Adrian had his moment in the sun. And I think a large part Adrian's moment has passed him, right? Whatever he was trying to accomplish, I think ended with Dobbs. And he put out this book, which is, how many pages is it?
200.
Yeah, I mean, it's a quick read.
Yeah.
It doesn't answer a lot of the issues I think he is. I think there have been some criticisms of his book by Bill Pryor, by Will Bode and Steve Sachs and others that have been, I think, fairly effective. And we'll see what Adrian looks like in a year. We're still talking about him. Maybe he will. Maybe he has sort of their legs to it. But I think in large part, had Dobbs come the other way, it would have been very different.
Oh, definitely different. Although I think you're underestimating the NatCon movement and the religious nationalists at this point, because again, Vermeulen may be an outlier as a law professor on these issues, but there is this growing movement of these sort of ultra-conservatives, I guess I would call them, of which he is now, even if he doesn't like to be considered
the patron saint
among them all, yeah, he's definitely part of that. And again, Deneen's coming Thursday. On Friday, just another plug, there's a noon meeting at the Ostrom Workshop across campus where I and two colleagues of mine will be talking about a book we're writing, tentatively entitled Who's Afraid of Liberalism? And it's essentially a defense of the liberal project, which would include, by the way, the Federalist Society, but it's against this national conservatism and the religious, religious nationalism and all this that have been growing since Well, especially since Trump took office. He really relied on
Yeah.
that movement heavily.
And I mean, it'll be curious what happens in 2024, the election coming up, if evangelicals turn away from Trump and they say, well, this is not our guy anymore, they tend to turn to another candidate. I think the current FedSoc leadership is sort of not trending that direction, but if the students, the rank and file coming up, gravitate in that direction, I think it's inescapable. So you have that conflict more.
Funding sources.
Yeah. Right. This Chick-fil-A is not free, right? So someone paid for it. But, from my perspective, FedSoc still has the same mantra of open ideas. Like, they don't tell me what to say. They don't tell me what I can't say. I've never had them yell, like, Josh, that's not the party line. We don't have that. If it were to become that sort of organization where someone would tell me to say a few Hail Marys if I sin too much, I think I'd have to find other employment. I'm Jewish, by the way, so definitely not saying Hail Mary. It's not going to work. All right, thank you. I think we're about time for Q&A.
Yeah.
Yes, we have time for several questions, so let's start over here. Hey, Josh, I have a question for you.
Yes.
So,
What's your name?
Ethan,
Ethan, thank you.
I'm curious when you frame the conservative legal movement and the rise of originals and the rise of supposed concern for history as a response to Roe in the 1970s, why you don't frame instead as what in my mind is a response to Brown v. Board in the 1950s, that the conservatives needed extensively non-racist reason to oppose the Warren Court and social progress, and originalism was their answer.
I think originalism wasn't a response to Brown. It really came about decades later. The massive resistance movement absolutely argued that Brown could not be supported by the original meaning of the 14th Amendment. They absolutely argued that. They said that Plessy was correct as a matter of original meaning. I think if you polled originals today, I think probably 100% would say that Plessy was wrong. And I think probably 80% would say that Brown was correct as an original matter. So I think there's definitely a overlap between some of the arguments made by the White Citizens Council, for example, after Brown, and originalists, but I think there's a big enough gap between them. Thank you for the question. Please go ahead.
And when we're looking at what does it mean for the conservative legal movement when you have tests that are coming from ahistorical cases like Bruin that when applied, we just had I think it was a second circuit decision that came out said even domestic violence offenders access to firearms, even those sorts of what we consider to be mostly common sense restrictions, that those would be invalid. What does it mean when the rules that are coming out of the movement aren't really making sense in the modern age?
Yeah, I think it was a Fifth Circuit case, but so this was a recent Fifth Circuit decision from a couple days ago, so you are on top of your game. Very recent. It was not a conviction for domestic violence, but it was someone subject to a domestic violence restraining order, if my memory serves, right? Before Amy Coney Barrett was on the Supreme Court, she wrote a decision called Cantor, Kanter, in which she reached a very similar conclusion. And she said even before Heller, even before Bruin under Heller, that the domestic restraining order prohibition was not constitutional. Here's what I'll say. I think the Bruin case could have done a much better job explaining how to use its analogical reasoning. And the reason why I say this is that none of the litigants asked for that test. If you read the briefs, not a single party said, here's what we want to do analogies. But during the oral argument, Justice Thomas asked Paul Clement, the lawyer for the plaintiffs, so if we're going to do this with analogies, how do we do it, right? Think like the LSAT, right? You have an analogy. This is to this, this is to this, right? I think the court's going to have to tweak that test. I would have preferred the court did it last term, but they didn't, and I think it's unfortunate. Some of the bans on former felons, I think, are harder to justify. For example, a nonviolent felon, right? Let's say you had a nonviolent felony, like Martha Stewart, like insider trading, right? Or, some sort of white-collar crime that didn't involve any violence. I think it's harder to justify a lifetime ban on the right. If there's a conviction for a violent offense, I think it's easier to do it. The restraining order is trickier because it's sort of this like emergency thing without the full amount of due process you'd often get, and a person may have justified later in life that they didn't need to have this prohibition put upon them. So I am not a fan of people losing their rights indefinitely because of a single order, which is what the statute provides. But your question about common sense, I get it. If the court puts out tests that don't pass sort of the laugh test, so to speak, it's going to be hard to keep them alive. So I definitely hear your question. Thank you.
All right, let's do some more questions.
You mentioned the weakening of the Lemon test after Kennedy, and it's my understanding that the Jewish faith tradition does allow for abortion. Could you see in the future a freedom of exercise claim for abortion coming from the Jewish faith tradition?
Well, I actually filed a amicus brief in your Indiana Court of Appeals on that exact issue. So, are you Jewish? No?
No, I'm
Okay. Oh, anyway, so if I misspeak, you can all correct me.
100% Jewish up here.
100%?
100%.
Members of the tribe up here, okay? I want to make sure I answer this question carefully. There are some Jewish women who say that they have a religious obligation to have an abortion in certain circumstances. Not just that the religion permits it, but it's actually a mandate. Like thou shalt not kill, thou shalt honor the Sabbath. You see, thou shalt have an abortion in certain circumstances where their health, and they include mental health as well, may be at issue. And plaintiffs in Indiana and in Florida and other states have brought suit not just under the Free Exercise Clause, but under the RFRA, that is the Religious Freedom Restoration Act. This is a statute enacted by about half the states, which applies strict scrutiny to neutral laws that burden religious exercise. And they argue that abortion laws that ban pre-viability abortions or even pre-birth abortions intrude their religious obligations. Now, some of the plaintiffs are Jewish women, others are, Unitarian Universalists, and then with their friends at the Church of Satan, who've actually argued that abortion is a satanic ritual that they need to follow. Okay, you're laughing, but the Church of Satan brought suit in Indiana, or the Satanic Church. I might be getting the name wrong. I apologize to any Satanists in the room. If anyone watched the Grammys last night, whatever, right? There are problems with that argument. So first off, the state can still burden religion if they have a compelling interest to do so, and they use what are called the least restrictive means. And our brief discusses at some length. Protecting life is going to be a compelling interest. I know the plaintiffs say it's not. The courts will say it is. This is not going to work. The trickier one is actually the least restrictive means prong. And let me explain how this works. Most abortion laws have exemptions. For example, in Indiana, if a woman is raped, there's an exemption. If her life is in jeopardy, there's an exemption. If there's certain types of fetal abnormalities that would result in the baby dying within a short period of time, there's an exemption. And the plaintiffs argue that because there are exemptions, that the law is not sufficiently narrowly tailored, that it's under-inclusive. Again, I get the argument, but it's going to be hard for this to justify because all laws have some exemptions. I'll give you an easy example: murder. The murder statute is a self-defense exception, right? Crimes committed in the heat of passion are maybe going to be manslaughter. So there are lots of laws about protecting life that have exemptions. But again, I have an amicus brief on this. I won't want to belabor the point. People are leaving, so I'll wind down. But I thank you so much for the question. What other questions?
Do you have more questions?
Yes.
Yeah, so I'm Ryan. My question is for those of us who might be more progressive in the audience. We're trying to understand the conservative people movement in the Federal Society. To what extent would you say that the rank and file members of the Federal Society come there? I guess that's the chicken and egg question. To what extent is originalism what motivates people in the conservative legal movement? To what extent is a pre-existing conservative ideology
Good question.
with the originalism as the explainer to follow?
It's a really thoughtful question. I do appreciate that, especially coming from a progressive student. Let me put it this way. Among academics I'd say the majority motivated by the methodology. Among law students, maybe you all could tell me, but I would say 50-50. Is that generous? What do you think? You're nodding. Among people who vote for Republican candidates and favor Trump because he'll put conservative judges, it's probably like 90-10 the other way. So I think you have to look at sort of the different gradations. Most of the people who favor Trump to appoint a Scalia replacement didn't do it because they wanted a originalist committed judge. They want someone to get rid of the abortion cases, right? I think most law students who tend to be FedSoc members, I'd say more than half, are motivated by the methodology. There might be some of them who, like everyone else, motivated reasoning is a strong medicine. They may think they're motivated by methodology, but really they're leaning towards it. The test I often give, which I encourage you all to do, is you ask yourself, would I hold this position if it was the other way, right? If the other side was in power, would I still favor this position, or if there was the other precedent? Or even worse, does my legal position lead to an outcome I don't like? So the classic example is flag burning, right? Justice Scalia would have hated flag burners in his life, but he voted to uphold the right to burn an American flag. And there are other examples as well, right? Is your position on abortion perhaps different than the one that would lead, do you oppose Roe but favor abortion rights? If so, then you're in a good spot, right? But if you favor Roe and you favor abortion rights, well, then things just line up neatly, don't they? But good question.
If I could add on here, the point about motivated reasoning is excellent. Even Justice Scalia was not always an originalist.
Nope.
On Fifth Amendment takings, there was no original meaning that supported his interpretation of the takings clause for regulatory takings purposes. The same with Justice Holmes in 1922. It just wasn't the case. So they had to, I don't want to say that some amount of judging is always functionalist or instrumentalist, but I sort of lean towards that because it's hard to explain otherwise. And I'm not saying this just about originalists, it's also about, liberal judges too.
Okay, I think we have time. We have time for more questions.
We got time for one more. We have one more. Or good. All right. Well, please thank you.
Thank you. I have a question for you.
Of course.